Hariharan,
which has been stayed.
Mr. Hariharan, one way can be that without any referring to any details, we set aside the order and request the High Court to pass a fresh order.
No, my lord, I essentially am, and there are issues which I need to address your lordship on. Because here is a situation, there are two basic issues, my lord. One, I have been taken into custody, one on the premise that I am a public servant. That aspect your lordship will look into. The second element is that the child is a minor. The prosecutress was a minor. I am in a position to show that she was not a minor. On both counts, I don't know why I am in custody.
Lord, I'll answer that question first.
There is a finding from none less than the Board of Aims that she was more than 18 years of age at the time when the incident happened. There are 6 opinions, medical opinions in the favor of the person.
Request the High Court to look into all these aspects and pass a fresh order. We can also request the High Court that before the summer break, the appropriate orders may be passed.
On the bail application, my lord? Very good.
Lord, may
On the
I say
suspension.
only one thing? Lord, the entire order, impugn order proceeds on the ground whether it applies section 3(4) or 5(6). Lord, I will go into, if required, my lord, in the controversy about the age, etc. But the main conviction is under section 376(1) for remainder of the life. Lord, the High Court has, Lord, not taken into consideration that
That
and
is what we
say,
are, Mr. Solicitor, that is what precisely we are noticing. That even according to you, some aspects of the issue could not be taken notice by the High Court, while considering the prayer was limited only for suspension of sentence.
yes,
Let us also keep that margin in mind. High Court was not hearing the appeal. Maybe at the time of hearing appeal, the issues are enlarged and then detailed arguments are taken. Probably both sides went on the premise that only a suspension application is being heard. But you are right, there are issues which requires maybe judicial.
Lord, important issue which may require adjudication is whether MLA is a public servant for the purpose of POCSO Act.
Exactly.
In Antule's case, the limited point was
that hyper-technical approach High Court has taken, we do not endorse.
yes.
No, my lord, I
Because,
will essentially, my lord,
in
convince you on
PC
that.
Act, whether sanction is
Your lordship
required.
need to hear me.
We understand that you are taking advantage of.
I am not taking advantage, my lord.
Or in the
The-
POCSO Act saying that any definition.
That is
of
why I start,
relate-
your lordship, I started,
But this is a legislation which is not only a penal legislation, it is a legislation which protects women, children from sexual exploitation and
when
other
the,
forms of
my
grievous
lord,
crime.
my lord, it is, my answer to that.
Position of dominance,
There are-
that is the test.
See that there's two difference, right? Section 21 of the old penal code and the definition of public servant under the Prevention of Corruption.
Unless context otherwise
If you
requires.
see Prevention of Corruption Act,
My lord,
if
my-
MLA goes into public servant basket.
No, the trial
Now,
court,
my
trial
lord,
court, only a minute.
can I
Mr.
get an
The
answer
trial
on that?
court records the finding
Mr.
that
Aliya.
MLA is in a dominant position
Mr. Solicitor.
under
My lord,
section 5.
Mr. Solicitor. Mr.
my lord, this is,
Just listen. You see, let us also have always practical aspect in mind. There is an order passed by the High Court suspending the sentence, right?
after, my lord, 10 years of custody.
So, right, in your favor, we are saying so. That order is stayed by us. Now there is a suspense. The order is illegal, the order is erroneous, the order is correct, the order is partially correct, the order is partially incorrect. When this state of mind is there, High Court probably will be reluctant even to take up the main appeal because some of the issues sometimes while touching, because when you need to pass a speaking order in suspension of sentence, you unwittingly touch the merits also. And when you touch the merit, then you know that if the appeal is taken on merits, those issues will again arise. So what will happen? The High Court will be waiting for us to now opinion. Our predicament is that at the stage of suspension of sentence, if we express any opinion, unfortunately for that issue, one of you will lose the first
The
place.
option will be closed. The option will be closed. If your lordship expresses a view on that, the option will be closed as far as either I am concerned or the other side is concerned. I am conscious of that.
So therefore,
that is why, my lord,
one of you will lose one platform. For that purpose, we were only saying that we, without any saying that order is erroneous, illegal, or not erroneous, we set aside the order, send the case back to the High Court with two options. One, that either you decide the appeal itself, Or if you feel that the appeal is likely to take some time, please pass an appropriate order on the application for suspension of sentence after hearing all of it.
And
Lord, now
without
what
being
happens is-
influenced by the
Now, can I just come
order
to
under challenge, my lord. Without being influenced by the order.
Of course, once we set aside that.
Your lordship, sir.
Your Lordship, once the order gets set aside, in a way, it is a kind of a reflection of an opinion of the
No.
superior court to the High Court.
All right, we are offering you the order which we want to pass. Write down.
No, my Lord, one more thing.
Just a minute, we are only giving you a draft order, we are
Wait,
not
wait.
passing the final order. We are only.
Anything that falls from your Lordship's mouth,
Just one thing I wish to say, my lord, there are additional grounds.
Just a minute, please. During the course of hearing, it transpires from the rival submissions that in addition to the issues which have been prima facie touched by the High Court while passing the impugned order re-suspension of sentence, there are several other issues which too require to be looked into even at the stage of passing an order on suspension of sentence. Also, keeping this in mind, and without expressing any opinion on merits of the, on merits of the prayer for suspension of sentence, we allow this appeal in part, set aside the impugned order, and remit the case to the High Court with the following requests. One, the High Court may make an endeavor to decide the main appeal as early as possible.
my Lord, there are 5 occasions where I have already argued this appeal completely. My Lord, why am I being put to fault on this aspect?
See the order first, then you will decide.
I don't know what more I can do.
Finally, as early as possible and preferably within 3 months, more so when it is us before us that the appeal has been on the earlier occasions argued at length. 2I, in case the High Court finds that the appeal is not likely to be decided early, it may pass a fresh order, re-suspension of sentence on the prayer for suspension of sentence, after hearing the parties, including the counsel for the victim complainant. Also, in this regard, it is clarified that while setting aside the previous order, we have not expressed any opinion on merits of the prayer for suspension of sentence also.
But only one request I would,
Will not be governed by.
only one request. if
Can
I-
it be subsumed?
Main appeal, nor the prayer for suspension of sentence shall be influenced by the observations made in the order.
Only one request I'll make, my your lordships initially were pleased to write that there are some additional grounds which are not considered. My lord, the grounds considered also, my lord, needs to be revisited. For example,
Yes.
whether he is a public servant. So kindly clarify, including grounds which are considered, maybe requires reconsider.
No, I am,
Because
it can
there
be
is a
done in a
finding
very
that
simple
public-
fashion. Let the,
Yep.
Upon which the High Court has made certain, has given a prima facie opinion.
I have a suggestion based on what my learned friend is saying. Let the suspension application be heard afresh and all grounds be considered.
Yes.
That's all,
He's saying that let the application proceed.
without prejudice to either side.
But that is exactly what is done.
That is what is being.
If you want, we can limit that also.
That's all I am saying. my lord.
All
But,
the-
my lord, no, my lord, I'm sorry, my lord. I'm sorry, my lord, your lordships may have to say something about the findings recorded.
That is what we have observed,
Exactly.
that the fresh hearing will not be hindered by the observations in the order that we are setting aside. So that.
My lord, I have much to say on that. My friend may say something. I have
no
also much to
difficulty.
say.
I am ready to
I'm,
assist.
your lordship may decide otherwise against me, but hear me.
You have very compelling textual arguments to make. We are conscious of it.
Not, they are not textual alone.
I am ready to lose on that ground before your lordships. If he wants, my lord, we can argue here also.
We don't want to make any observation.
That will-
That's entirely your lordship's
The
prerogative.
date of the final appeal.
The order may be, appropriate order may be passed, preferably before the commencement of the summer vacations.
Your lordship gave some systems wise,
Orders may be passed preferably before commencement of summer vacation.
in the suspension. process.
Application for suspension of
Very-
entire. Now,
because the
मेरा कोई
appeal-
part we have deleted.
Very well. Very well.
Right.
I am grateful, Lord.
Oblate.
Gratefully.
Oblate the order.
Yes, it's.
Order
Uh-huh.
is set aside
Exactly.
on all points. Because cannot be argued.
The order is set aside, set aside on all the points.
Oblate.